Hello everyone, and welcome to the third and final Brodie's Oil and Gas Academy session of our winter series. My name is Clare Munro and I head up the Energy and Infrastructure team at Brodie's. Today we will be looking back at some of the key developments which occurred during 2020 and discussing their potential impact going forward. We are covering various different topics today, and our first two speakers are going to look at the revised OGA strategy and the UK Energy White Paper. Vanessa Castillo is a senior solicitor in our oil and gas team and is experienced in both onshore and offshore projects, having advised clients on infrastructure agreements, corporate and finance affairs, and international arbitration. She is qualified to practice law in Venezuela and advises clients in both English and Spanish. Ross Gardner is a solicitor in the oil and gas team, advising both upstream and service sector clients. Ross gained valuable in-house experience during time spent on secondment to an operator, as well as having worked for the UK regulator for environment and decommissioning prior to becoming a lawyer. Over to you, Vanessa.
Thank you, Claire. Good morning, everyone. So two of the main topics for 2020 in the UK's oil and gas industry were the publication of the OGA revised strategy and the Energy White Paper. The new OGA strategy, published and submitted to Parliament on the 16th of December 2020, was the result of a 12-week consultation which ran from the 6th of May until the 29th of July 2020. The revised strategy came into force last week on the 11th of February. The strategy derives from the obligations set in the Petroleum Act 1998 for the OGA to produce a strategy for the development of the objective of maximizing economic recovery, to be reviewed on a 4-year cycle. This is the first revision of the strategy since the OGA was established. The strategy has been renamed from UK strategy to OGA strategy as an indication of the expansion of its main objective or purpose. In addition to the central purpose of maximizing economic recovery, the OGA must also support the move to net zero carbon by 2050. It extends the central obligation imposed to relevant persons, which before was merely focused on maximizing economic recovery, to now include taking the necessary steps to assist the Secretary of State in meeting the net zero target, including the reduction of greenhouse gas emissions from sources like flaring and venting, and supporting carbon capture and storage projects. The strategy also includes changes and amendments in different sections, including the supporting obligations. Here, we will discuss some of the most relevant ones. It introduces an obligation in governance, which will allow the OGA to direct some governance principles and practices to offshore licensees. This was questioned during the consultation by 24 of the respondents, which expressed their concern on the value and purpose of this obligation, as they believe that this will give the OGA the ability to interfere in routine affairs of companies. On exploration, there were only a few small changes included in the wording, but now there's an obligation for licensees to inform the OGA as soon as they become aware that they won't make a satisfactory expected commercial return on their investment or activity. On development, it includes the obligation to consider whether or not any existing or proposed infrastructure could contribute to the net zero target, and provide support for any CCS project. Some of the respondents suggested that this obligation should only apply when there is a real prospect of CCS facilities being developed relating to the concerned infrastructure. Then on asset stewardship, it adds the requirement of achieving optimal levels of performance with energy efficiency, and introduces the requirement to reduce as far as reasonably possible greenhouse gas emissions and achieve optimal potential for reuse or repurpose of infrastructure, again considering the net zero target. It also includes a requirement for owners and operators in relation to metering and measurement of emissions, which some of the respondents believe that it was put in a way that was too broad in this new strategy. On technology, there's now an encouragement for technologies to reduce greenhouse gas emissions, enable CCS projects and hydrogen projects. The wording was changed to encourage, following the respondents' observations, considering that the development of new technologies is not part of some of the relevant persons' business models. For the commissioning, the new strategy states that the relevant persons must ensure and be able to demonstrate that all continued or alternative uses for infrastructure in a region, including for CCS, have been suitably explored before commencing the commissioning. Collaboration was moved from the required action section to the supporting obligations, and the wording has been amended and in a way simplified, and it will apply while undertaking relevant activities. It still calls for collaboration between other relevant persons seeking to acquire an interest or investment in offshore license or infrastructure. And although it's not binding on the supply chain, it does call for collaboration with it. During the consultation, some of the respondents were against this move of collaboration from the required action section to the supporting obligation section, explaining that collaboration has been delinked from the central obligation and has become an end rather than a means to an end. Others believe that the loss of detail in the wording could lead to more disputes instead of less. The OGA has clarified that the linking was not the intention of this move, and that's why it states in the strategy that the collaboration should be done while undertaking relevant activities. Finally, we can see that we have a new carbon capture and storage projects obligation that was introduced for relevant persons to have due regard to CCS projects. Some of the other amendments that were included in the strategy, we can mention that in the required action section, there's a reference to the stewardship expectations published by the OGA. And during the consultation, the respondents welcomed that the OGA reassured that any new stewardship expectations will be developed jointly with the industry. On cost efficiency, for instance, now we have a mention to the reuse and repurpose of infrastructure. And we have amendments to the existing definitions, and we also have new definitions that were included being the most relevant ones for this new approach, the definition of carbon capture and storage project, and the new definition for net zero targets. To conclude, it is clear that this revised strategy seems to mark the beginning of a new era focused on the net zero targets. And the clear challenge from this strategy seems to be how to balance the two central obligations. And it will be interesting to see how the relevant parties will shift their operations to meet the new goals and standards set in this strategy, which can only be achieved with their cooperation and compliance. Some of these new standards and obligations don't fit all the relevant parties in the same way. So we will also have to see how they will be adapted in practice to the reality of each relevant person and how they will be developed together with the points set out in the Energy White Paper, which will now be explained by Ross. Thank you.
Thanks, Vanessa. So I'm going to discuss some of the key points for the oil and gas sector set out in the recent Energy White Paper. So following on from the UK government's 10-point plan, the White Paper was published in December with the title Powering Our Net Zero Future. And like the new strategy, the White Paper places significant emphasis on the net zero commitment. And the majority of what is set out in the paper is considered in the context of the energy transition. So focusing on oil and gas, which is covered in Chapter 6, I think an important starting point here is to highlight the fact that the UK government in the paper recognises the crucial role to be played by the oil and gas sector for years to come and through the transition in ensuring security of energy supply, making a significant contribution to the economy, and the fact that the OGA estimates there to be 10 to 20 billion barrels of oil remaining on the UKCS. So net zero and Majeure UK aside, there are a wide variety of considerations for oil and gas companies to weigh up and balance, both in terms of their short to medium term oil and gas operations, but also their perceived role in the energy transition. And I would say to an extent, a number of these considerations are outlined in the white paper. Significant investment is expected for new energy projects such as carbon capture and storage and hydrogen, and dedicated strategies for both of these are expected in the first half of this year. But how do we get from where we are now to these new energy projects happening more widely and a greater diversification of the energy mix? Well, given that the vast majority of North Sea operators will have some sort of decommissioning liability, and decommissioning is obviously going to be a huge task over the coming years, perhaps decommissioning is an appropriate stepping stone. And with that, the paper recognises the opportunity for the reuse of infrastructure for new energy projects, as well as retraining and upskilling the huge pool of talent that the sector has. The paper commits to working with industry, as well as developing technical guidance on how reuse can be done practically, safely, and securely. And obviously the detail of this is going to be incredibly important. And linking back to what Vanessa said in terms of the strategy, a one-size-fits-all approach is not going to be practical. individual circumstances, integrity of certain wells, certain pipelines, location of certain infrastructure. That's all going to impact on whether a new energy project would be viable, and then again, if it's going to be viable for a particular company. So what can the industry expect in the coming months and years? Well, if we just go on to the next slide, the North Sea transition sector deal is expected in the first half of 2021, and the paper explains that this will establish a new partnership between government and industry, and this is likely to be key in the transformation of the oil and gas sector. It's expected to sustain jobs, and details of this are obviously eagerly anticipated. In terms of regulation, the paper sets out that the government will work closely with both the OGA and OPRED to ensure roles, powers and priorities are aligned with net zero policy, and importantly, without additional regulatory burdens being imposed. The paper also intimates that OPRED's focus on emissions will very likely increase, and Laura's going to discuss this in her presentation. Licensing is specifically mentioned, so importantly, Majeure UK is still there. However, it might be that certain aspects of the license regime need to be formalised in order to align with net zero. So this might come in the form of additional processes being added before future licensing rounds commence. No mention of cross-sector regulation in the paper, which I just wanted to flag. So this will obviously be important in the coming years, particularly when it comes to making cross-sector projects achievable and efficient. So, for example, the electrification of oil and gas platforms. So something to bear in mind. And in that vein, critical to energy companies making the move from strategizing to delivering new energy projects is information, and more specifically, tangible commercial frameworks and business models. It will only be once this source of information are publicly available that companies will genuinely be able to commit to new energy projects, to commercialize them in the context of their organization and scale them up. Such models are expected over the next couple of years. And running in tandem alongside that is investment. So the white paper sets out that a revenue mechanism will be established later this year, detailing how the necessary private investment conditions will be established to ensure that there's continued healthy investment in oil and gas, given its importance. And this will need to factor in considerations such as sustainability and ESG reporting. So to conclude and to try and bring this back to what I mentioned at the start, I think what's coming for the oil and gas sector is opportunity, with the white paper paving the way for a new chapter. And key to the success of the next 5-10 years and beyond will be many of the commitments made in the paper and the publications which are expected. So the details of the forthcoming sector deal, the business models, revenue mechanisms, as well as publications on putting the UK decommissioning and supply chain on the world market. So both operator and service sector companies should be looking at their objectives, their strategic plans, engaging with their workforce, the regulator, and identifying the opportunities that their business might want to pursue in the next 5 years through the transition, both in light of the white paper, strategy, and looking ahead to the forthcoming details. And with that, I'll hand back to Claire.
Thanks very much, Vanessa and Ross. So we're now going to move on to look at a couple of issues related to Brexit. Our next speaker is Elaine McElroy, who is going to look at frontier work permits. Elaine is a partner at Brodie's. She heads the firm's immigration offering and acts for employers across the UK in a range of sectors, including oil and gas, education, financial services, and healthcare. In addition to immigration, Elaine also advises on the whole spectrum of employment law issues, with a special focus on 2P and strategic advisory work. She regularly appears in employment tribunals across the UK and is interested in all areas of discrimination law. Diversity and inclusion is a passion of hers. Elaine, if I can hand to you.
Thanks, Claire. So today I'm going to talk about what oil and gas employers need to know about frontier worker permits. The There are a whole range of immigration changes that have been brought about by Brexit, but this is one area that's been less publicised than some of the others, and it's also brand new, so hopefully now is a good time to look at the changes. And we've been receiving queries from some of our oil and gas clients in relation to this. So in terms of background, the Frontier Worker Permit Scheme opened on the 10th of December 2020, and it's one of the impacts of the end of freedom of movement. So until the end of the Brexit transition period on the 31st of December, EEA citizens could come to the UK and they could work without any need for a work permit. That's of course changed, and for Europeans coming to the UK for the first time to work since the 1st of January, they have to apply for some sort of visa through the new points-based immigration system. But for those EEA citizens who were already exercising their free movement rights before the transition period ended, by being a cross-border worker, so living in one country and working in another, the withdrawal agreement contains specific provisions to protect their rights and to enable them to continue to do that. So this scheme was introduced in the UK to implement those commitments in the withdrawal agreement and in the EFTA separation agreement and in the Swiss Citizens' Rights Agreement. And I mention that because there are reciprocal provisions in other European jurisdictions to protect the rights of frontier workers. So if you are sending employees to other countries in Europe, they may well have similar schemes, albeit with their own rules applicable to those. So the scheme was introduced in a set of UK regulations. I've put those up onto the slide, and they were published towards the end of last year. And it's worth noting that applications under the scheme are free. So just like the EU settlement scheme, there's no visa fees, unlike applications through the points-based system. So that's a major advantage of this type of permit. And there also aren't additional costs like the immigration skills charge, which applies to other types of visa, usually £5,000 per 5-year visa. So another considerable saving. And for the individual themselves, they don't have to pay the NHS surcharge, which can be a significant upfront cost for people. So lots of benefits there. And it's a very flexible form of permission to work, and that allows individuals to take up employment or self-employment, so suitable for contractors as well as for employees, and people can also switch from one to the other. They're not tied to a specific form of work or employer or job. And the main downside is that it doesn't lead to residence, but it's not really intended for those living in the UK. And there's quite a short window for applications, so it is worth knowing about this scheme and knowing about the timescales for it. So for those who want to continue coming to the UK for work from the 1st of July, they have to get the permit in place by the 30th of June. So although the scheme won't close as such, for those coming to the UK regularly for work, they'll want to get it in place soon. And there is paperwork, etc. to submit. So it's worth not delaying with those applications if you've got employees who need to make one. Just moving on to the next slide then, in terms of who is eligible under the scheme, it's worth noting that the UK has taken a really broad definition of frontier worker, broader than the kind of typical European definition. So lots of individuals will be able to qualify under the scheme if they've been coming to the UK to work. And there's 3 key requirements. First of all, the individual must be an EEA or Swiss citizen. Secondly, they must be primarily resident outside of the UK. So it's not for people living in the UK who are likely to be able to apply under the EU settlement scheme. It's for those whose primary residence is outside of the UK. And in terms of how that's defined in the rules, that's usually for individuals who spend less than 180 days per 12-month period in the UK. But even if individuals don't meet that element of the definition, they can still satisfy this requirement to be primarily resident outside of the UK if they return home, usually twice in every 12-month period. So it's a pretty flexible definition there. And then the third main element of the eligibility criteria is that there's a requirement that the individual was either taking up employment or self-employment in the UK before the transition period ended, and in that 12 months before it ended, and also that the person continues to be a frontier worker by coming to the UK for work. And in the rules, they basically require that in addition to having worked in the UK in the 12-month period before the transition period, ended, you have to be able to show that you came to the UK once for work per rolling 12-month period. So if you came to the UK for work, for example, in June 2020, you would have to return for work before June 2021 in order to meet the requirements. So it's pretty flexible in terms of who qualifies. And even if an individual doesn't meet those requirements, it's worth bearing in mind there's special rules for those who retain their status as a frontier worker. And that can be individuals who would have been coming to the UK for work, but couldn't because of reasons such as pregnancy, childbirth, illness or injury. And there's also special rules relating to COVID and the guidance. So even if you think that somebody may not qualify, it's worth checking the detail in the rules. And there's also special rules about those who've not been able to come to the UK for work because they've lost their job. So they may still qualify under these special rules. And if we just move on to the next slide, the individual has to demonstrate that the work that they were doing in the UK counts as sort of genuine and effective employment, and it cannot be something which is marginal or ancillary to their situation in the UK as a whole. And the guidance basically sets out that the work that the person must have been doing in the UK shouldn't be things like a one-off attendance at an interview or coming to the UK for a short meeting. It should be genuine and effective employment, and they give examples of what that might be. So for example, coming to the UK to work for a few weeks would count, or if it's part of somebody's job to require them to come to the UK regularly, that's likely to count, but short one-off activities may not. And there's no need for the individual to have a contract of employment with the UK entity. It might be that there's a group company that employs them, but they come to the UK to provide work for a business in the group, for example. But what matters is that there's some sort of arrangement to provide work in return for pay. And if individuals do apply, they'll be expected to set out how frequently they come to the UK, how much work they do, and what element of their pay relates to that UK employment to show that they do take up genuine and effective work in the UK. If we just turn to the next slide, thanks. So the benefits of the Frontier Worker Permit as compared to other types of work permit is that it is useful for those EEA nationals who work in the UK but live elsewhere. It avoids the need to apply for a visa under the points-based immigration system, which is likely to have stricter rules, and it might tie somebody to a particular job or employer, and it's likely to be much more expensive. So it's usually beneficial over a points-based system visa. Other clients have asked whether they could just rely on the visit rules if they've individuals coming to the UK occasionally for work purposes. In some cases that will be suitable, but there are quite strict requirements about what business visitors can do. And now that those apply to Europeans, lots of clients are having to think about them in a way that they didn't have to before when we had freedom of movement. So having a Frontier Worker Permit does allow the individual to work, and it avoids those worries about whether they're overstepping the mark in terms of the visit rules. As I'd said in the previous slide, there's no costs, it's free, so it's worth looking at if somebody does qualify. And then if you get a Frontier Worker Permit, it usually lasts for 5 years as long as the individual continues to be a frontier worker, and it can be extended indefinitely. So again, lots of flexibility there that the person can keep coming as a frontier worker as long as they continue to qualify, and they can take up employment, self-employment and work for anyone as well. So flexible type of work permit. And before I finish off, I just wanted to touch on some of the rules about business visits now that the Brexit transition period has ended. And again, we're getting lots of queries through. Lots of employers didn't have to think about the rules on business visits before, if they were largely sort of sending Europeans back and forth between the UK and Europe. But now that has changed, and lots of employers are having to turn their minds to this for the first time. So in the new trade and cooperation agreement that was agreed just before the new year, there are reciprocal provisions between the UK and the EU in relation to short-term business visits. Those provisions generally apply for visits from the 1st of January onwards. And for British citizens visiting the EU for business trips, they're not going to require a visa for trips for up to 90 days. In terms of incoming trips to the UK, The UK has amended its business visit rules, and that allows EEA nationals to come for up to 6 months, so more generous than those provisions in the trade agreement. And the UK business visit rules in terms of what activities you're allowed to do, those have also been updated. But in the trade agreement itself, there is an agreed list of permitted activities as business visitors, which gives some consistency across the EU, but it is worth bearing in mind that there are some countries that have agreed specific exceptions to those rules. So there may be a case for seeking local advice, depending on what jurisdiction you're sending somebody to. There are also provisions in the trade agreement that deal with intra-corporate transferees, so group companies sending people across the EU for work purposes, and also they deal with independent professionals going to perform work in other jurisdictions, and also contract service suppliers. So just worth remembering that those provisions are in the trade agreement and then will be implemented into local laws across the whole of Europe. But the main point to take away is that some planning is likely to be required if you have been used to relying on freedom of movement, which has meant nobody needed to worry about the rules on work or business visits previously. I'll now hand back to Clare.
Thanks very much, Elaine. Our next topic is emissions trading and the transition from the EU ETS scheme to the UK's own scheme. And taking us through that will be Laura Petrie. Laura is a legal director in our oil and gas team with significant experience providing corporate and commercial advice to upstream oil and gas clients. She frequently advises operators on a range of exploration and production matters, including operational issues, general contracting, and asset restructuring. Laura also has significant service sector experience advising clients on the use of standard form contracts and the preparation of bespoke terms and conditions. So if I could pass over to you, Laura.
Thanks, Claire. So the point made at the start of this seminar by Ross and Vanessa is that the UK is seeking to imply more ambitious targets in relation to net zero. And as part of this, and as part of Brexit, the UK system for emissions trading scheme has been set up, and that became live on the 1st of January 2021. The UK inputted massively into the EU system when it was being created and generated, and therefore the system that the UK has now set up is largely modelled on the EU system in form and functionality, save for two very specific differences. And these tie in to this net zero target that the UK has set. So firstly, there's going to be a lower annual cap permitted on emissions and available allowances overall. The EU cap for the 2021 phase of the scheme is still to be confirmed, but the UK cap is being taken down to 155 million tonnes for the 2021 session. And this is less, obviously, than the 2020 permitted cap under the EU scheme, and is anticipated to be less than the EU cap that's going to be confirmed. There's also going to be a slightly higher fine imposed in relation to any breaches of the scheme rules, although largely this is going to be very dependent on exchange rates. It's proposed to be £100 compared to €100, so the difference is not massive, but if the exchange rate alters in any way, it could be quite a significant difference compared to our EU counterparts. Initially, there will be the same free allocation made of credits under the EU and UK schemes, the same way that there always has been, and the same benchmarks that are being proposed for phase 4 of the EU scheme will also be applied in the UK scheme. And phase 4 of the EU scheme commenced on 1st of January, just when we had the switchover for the UK scheme as well. Auctioning is going to continue as the primary means of introducing additional allowances into the market, but they will have a £15 reserve price. So the UK is intending to try and set a floor for all pricing to limit trading and manage any transfer and trading of those allowances. So moving on to how this looks against the EU scheme and what we have to do to prepare to exit from the EU scheme. Operators are required to comply with the EU ETS regulations for the 2020 scheme year, which ends on the 30th of April this year. And the same process as has always been followed will still be required to be followed for this session. So verification of emissions must be submitted by the end of March, and then the allowances for those emissions must be surrendered by the 30th of April. But 30th of April is a really key date in relation to the EU ETS scheme, because after the 30th of April, it's anticipated that UK-based operators will no longer have access to their accounts. The EU scheme managers have said they don't think that the system will immediately lock operators out, but they don't know, because usually the system resets at the end of a scheme period and then re-allows access for all those member states that are still engaged in the scheme. And as of 30th April, the UK will no longer be permitted to access that scheme. So the key point to take away from today is that if you are holding any EU ETS credits in excess of what is required for surrender for the 2020 scheme, you need to consider what to do with those and how best to dispose of them. To avoid the risk of the loss of value, they can either be transferred to a trading account administered by another EU member state, they can be sold to other EU ETS participants prior to that 30th of April date, or if you are in a group that contains EU registered companies as part of the group structure, they can be transferred across to those entities if they are going to require credits for the 2021 scheme under the EU rules. One of the key things to remember from all of this is the date. And obviously that should be 30th April 2021. And that's the key date to take away from this and to remember. So if you're needing to do anything with your ETS credits that you hold under the EU scheme and you're going to have an excess, make sure that you are planning and future-proofing to retain or realise the value for those. And I will hand back now to Claire.
Thanks, Laura. So next today, Adam Brooks is going to look at force majeure and how COVID has impacted this area of the law. Adam is an associate in our oil and gas team covering both the upstream and service sector. He has negotiated a range of upstream agreements and procurement contracts, including JOAs, contracts of affreightment, product sales agreement, and contracts for the provision of equipment and services. He's also worked on a number of M&A transactions, including high-value corporate and asset acquisitions or disposals and corporate funding agreements. So Adam, if I can pass to you.
Thanks, Claire, and good morning to everyone. I'd like to give you a short analysis of force majeure contractual provisions in the context of the coronavirus outbreak and discuss how some of the key learnings from 2020 might be applied going forward. I'll touch briefly on what force majeure is, how contractual performance has been impacted by coronavirus, and how force majeure provisions have been thrown into sharp focus because of it, and finally some of the key takeaways from the past 12 months. Firstly, what is force majeure? Simply put, force majeure provisions in a contract serve to suspend performance of a party's obligations without any liability to that party should a certain event take place which inhibits that party's performance. Customarily, the contract will set out an express list of events which might constitute force majeure. However, it's not the mere existence of those events themselves which trigger force majeure. The event must generally have the effect of preventing actual performance by the party. It must be the sole reason for that prevention, and it must be something that was out with the party's control. Contrary as well, perhaps to popular understanding, there's no legal requirement for a lack of foreseeability of the event, and contracts actually often don't provide for this. So in theory, a contract signed after the outbreak of the pandemic could still be suspended for force majeure due to coronavirus. How then has the pandemic influenced contractual performance, and what has been the effect on force majeure provisions? Well, we're all very well aware of how coronavirus has impacted commercial operations. Some sectors of the economy in the UK have been legally required to close, such as retail and hospitality. And amongst other things, there have been severe restrictions on domestic and international travel. In response to this, what we've seen from clients is that they've been reaching out to us in order to get an analysis of the force majeure provisions in their contracts to better understand the rights and obligations should performance no longer be possible. And it's been essential for them to know whether performance can in fact be suspended, whether any liability attaches to that, for how long suspension is permitted, and also what actions must be implemented by the parties to resolve the issue. We would also note that it's not just clients seeking to excuse performance who've been reaching out to us, but also those who are concerned that some of their suppliers might be unable to perform. If we go to the next slide, please. Going forward then, what should parties be looking out for in force majeure provisions? Well, first and foremost, when it comes to drafting an agreement, parties need to decide whether they want a specific event, be it coronavirus or something else, to be covered by force majeure. In respect of COVID, we have seen a client who refused to include a pandemic within their force majeure provisions. So it's not given that every client is going to want to have this apply. But if you choose to not have it included, then you have to ask yourself, does its omission make performance any more likely? If a party is unable to perform, the lack of a force majeure provision is unlikely to change that. And it may then push them towards exercising some common law rights. And have you considered whether the exercise of these common law rights are actually more beneficial or in fact more prejudicial to your organisation? Assuming a party does want to cover off a specific event, then getting the wording of any force majeure clause right will be critical, as there's no common law equivalent under English or Scots law to rely on. Whilst there is some underlying case law addressing disputes on interpretation of existing force majeure contractual clauses, force majeure is very much essentially whatever you make it under the contract. Again, looking at COVID or some future outbreak of a viral disease, when listing events that might trigger force majeure, our advice would very much be to expressly cover off epidemic or pandemic rather than rely on any generic act of God reference in the list of specified events. The reason for that is that the act of God reference might be linked more with weather or geological events, earthquakes and floods. And so that is things you might more commonly describe in common parlance as natural disasters. And it's not clear to us that COVID necessarily fits within that scope. I would add here as well that parties should be very careful about reliance on standard terms and conditions. If we take the Logic suite of contracts as an example, there is no generic act of God event included within their list of force majeure events, and nor in fact is there any reference to epidemic. Most force majeure clauses will include changes to the law within that list. Therefore, be aware of any multi-jurisdictional risks that this brings. Given that businesses operate in a global marketplace, you must be conscious how a change in the law in a foreign country might have an impact on performance. A current example of that could be the risk that countries will impose export restrictions on critical supplies necessary to manufacture COVID vaccinations. If a party does in fact receive or wishes to make a claim for force majeure, consider whether the claim complies with the contractual requirements. So firstly, is the trigger event covered within the clause? Has it supplied notice in conformity with the contractual provisions? Has it also taken all the necessary steps in mitigation, such as arranging meetings with its counterparty to discuss a way forward, or has it used reasonable endeavours to procure performance by an alternative measure? As a receiving party, make sure you're satisfied that the claim is genuine and isn't being used as a smokescreen for another issue. Force majeure is not there to get parties out of a bad bargain. And 2020, we also saw a sharp decline in the oil price coincide with the outbreak of the pandemic. Now, the price has recovered in 2021, but should it drop again, a counterparty might lodge a spurious claim for force majeure because the terms of the agreement are no longer commercially favourable to it. And of course, a price increase might also have that same effect. Finally, but crucially, we would advise parties to be proactive. We encourage you to get your organisations to engage with counterparties now to understand any performance risks and use the time that you have to review the terms of those agreements. It is, of course, likely to be far better if you get ahead of these issues now and ensure that operations keep running because you've managed to get a workaround in place. At this point, I'll hand back to you, Claire.
Thanks very much, Adam. Our final speaker today is Martin Sloan, who's going to talk to us about electronic signatures. Martin is a partner at Brodie's, specialising in IP, tech and data. Martin works with clients across a range of sectors, including oil and gas, financial services, media and the public sector. Martin's expertise includes technology, procurement, IT outsourcing, business process outsourcing, intellectual property, data protection and e-privacy. So with that, over to you, Martin.
Thanks, Claire. So I'm going to talk to you for the next few minutes about electronic signatures. It's something which, sorry, switch on my camera, that I guess we've all become a lot more familiar with over the last year or so, though the technology here has been around for quite a few years. So I'm going to touch briefly just on some of the, what I call the perceived pros and cons, because I think some of them are worries that perhaps when you see the technology are less of a concern than they might be. Talk a little bit about what an electronic signature actually is. So when we're talking about this, what do we mean? Look at what the law says, and then finish up with the really, I think, it's the important bit here, which is some of the practical issues that we all face when using electronic signatures. So we can maybe just move on to the next slide. So in terms of the pros, one of the big challenges with COVID-19 has been getting documents signed, and the fact that we're all working remotely, people are not in the same place. So signing a bit of paper, having the same people put a wet ink signature on that bit of paper is much more challenging. Electronic signing is advantages in terms of speed and ease. It's very quick once you're used to it. It's very easy to do, and it means that a completion that might take several days, if not weeks, to do remotely, if you've got lots of parties, can be done in a matter of minutes once the documents are set up. So that is a real advantage if you've got complex transactions or large numbers of documents and the parties aren't all together. There's also, for people who are signing lots of contracts regularly, there are reduced costs in terms of paper postage, scanning, all that kind of stuff. And those costs may be fairly minimal for a lot of transactions, but actually just in terms of how you store your contracts and where you store them, if everything is digital first, storing it electronically is much easier than a scan of a paper copy, and then you think, well, should we keep the original in case we have to sue? Do we need that for best evidence or not? We've got very large file sizes and all that kind of stuff. So going digital first has got lots of advantages. And there's also opportunities around innovation and digitization in terms of workflow, again, for where you're dealing with high volumes of contracts. You can simplify that experience, and that then ties into actually what lots of other people will now start to expect. So when you're contracting with others, people now generally expect to be able to sign a contract electronically in lots of situations, and that will just continue to increase as it becomes more and more normal. But there are various questions that we get asked around this. So is it legally valid for the contract to be signed electronically? Can that entity sign electronically? And there are some questions on that. There are some specific restrictions to be aware of. Is there an issue in terms of evidential weight? There's not, and we'll talk a little bit about some of the practical issues here. But this idea, I think, that people think you have to sign in wet ink in order for something to be binding is largely something of the past in terms of how the weight that's applied to the courts are very comfortable dealing with electronic documents. What's important is the type of electronic signature you use and what information you collect on that. Is there a risk of fraud or hacking? Again, I think actually used properly, electronic signing can be more secure, because the analogy I always use is that signing a document electronically using one of the well-known online platforms is a bit like putting a wax seal on it, because encryption technology is used to lock that document down. And once that's happened, you then know if someone tries to tamper with it afterwards. Whereas with a wet ink document, people could easily do page swaps, they could change things, and it's much harder to actually prove the integrity of that document. Counterparty acceptance is an issue to think about, particularly if you are dealing with cross-border transactions. You'll want to be familiar with what happens in that country, whether there are issues in terms of local enforcement. So that's something certainly to be aware of. And due diligence in future transactions. So if you are signing something electronically, you want to make sure that what you're doing here is not going to cause an issue if that contract is then looked at further down the line in due diligence, whether for a subsequent sale of an asset or a business or whatever that may be. And the final one, just around privacy, putting documents into the cloud. I think, again, we're all fairly comfortable with that now, so that's not one of the concerns that it might have been a few years ago. We move on to the next slide. So what do we mean by an electronic signature? Well, the law classifies electronic signatures into 3 different types. So we've got what are called simple, advanced and qualified signatures, and these are all based on EU law, which has been around for a number of years. And I think it's quite helpful just to actually understand what each of these means. So when we're talking about a simple electronic signature, that could be anything like putting your name in an email, it could be putting a scan of your signature into a Word document, but it also includes using the sort of standard functionality that we're all very familiar with Adobe Sign and DocuSign. So it's quite a large variety of signatures are covered by that concept of simple electronic signature. And in terms of how much authenticity you can put on that, it very much depends on what you're using. So clearly, putting a JPEG of a signature into a Word document is not very secure. Anyone could do that. You've got no idea that it's actually the signature that's done that. The document could be edited after you have after that's been done. On the other hand, if you use Adobe or DocuSign, then you can have quite a bit of confidence in terms of the document's integrity, and you get provided with some information on who actually signed the document, but it's all tied to information around the email address the signature was sent to, the date and time of signing and things like that. Moving up the chain, so you've got advanced electronic signatures, and this is functionality that's available in some of the online platforms. And the idea with advanced electronic signature is you have a unique certificate that's issued to a particular individual. So you should know that if it's signed by Martin Sloan, you'll be able to check a signature and see it was issued to me. But if you have limited recourse against the provider of that platform, if it turns out that actually someone else had used that signature, because the provider doesn't carry out any ID verification. And then at the top of the tree, we have what's called qualified electronic signatures. And these use sort of advanced encryption technology. The provider will carry out ID verification of the individual before the signature is issued, and they're very secure. So to get one of these, you used to have to physically meet someone and hand over your passport or other ID documents in the way that you would open a bank account. That can now be done all online via a video call, and then you get issued with a signature. And this is becoming more and more common. It's quite interesting, in terms of certainly certain EU countries, QBSs are used an awful lot. Some people have them as part of their national ID card or through their bank. In the UK, they're a bit less known. In Scotland, all Scottish solicitors have them through the Law Society of Scotland. But as I say, the changes in technology and availability mean that they will become much more commonplace in terms of their use. And that's a good thing, because they are the most secure form of signature, and you've got a high level of verification there. We can move on to the next slide. So what does the law say about the English law slide here is pretty short, pretty much anything goes. And part of the reason for that is that English law has not really prescribed any particular laws around the use of electronic signatures. Even the Land Registry now is accepting electronically signed documents, and there is various bits of guidance on how you go doing that. There's some practical issues around deeds, and these are really no different to the issues with wetting documents, but just remember that when you're signing with a witness, under English law, that witness needs to be physically present. So signing electronically, you can't have someone witness by way of a video call. The Law Commission in England is consulting on that, but just remember that if you're signing a deed, then if you have a witness, the witness needs to be physically in the room with the signatory and watch what's happening. Okay, move on to Scots law. So this rather colourful table here tries to summarise what the position is under Scots law. And the reason it's so complicated is that we have had specific legislation since 2014 on this. But the key point to note is that for the majority of documents, a simple electronic signature is fine. But if you are doing anything that falls within Section 1.2 of the 95 Act, which is things to do with land or certain trust deeds or things like that, then you need to use advanced electronic signature. And if you want your document to be self-proving, so there's a presumption it's been signed by the individual who signed it, then you have to use a qualified electronic signature to get that status. That's the only way to do it when you're signing electronically. Okay, so maybe move on to practical issues here. So I think the key takeaway for me here, and what I always say to clients, is that the different electronic signatures provide different levels of assurance, and what's going to be appropriate will very much depend on what the contract is that you're dealing with and what the risk of challenge is, what the risks are with that contract. If you use platforms like Adobe Sign or DocuSign, then even with the basic signing functionality, you will get information on the email address that the invitation to sign was sent to. You'll get told the date and time of signing. You'll get information on the IP address of the device that was used. And all that is useful in terms of dealing with any potential challenge. But actually, for a lot of supply contracts, once it's been signed, people will start performing, and it's unlikely people are going to ever claim that they hadn't actually signed that contract. You might possibly have an argument over which version of the contract was signed, but it's unlikely that anyone's going to deny they've actually signed it. And in many cases, they'd probably be barred from doing so. If you can show a particular organisation had signed that document, it'd be quite difficult, I think, for that organisation to then challenge that they were bound by it. With suspensive contracts or things that are going to be relied upon in the future, that is perhaps more of an issue. So if you have something that only comes into effect further down the line, guarantees are a good example here, then you want to be a lot more careful. Self-proving documents under Scots law, I know that when we do Scots law documents, we can often have them witnessed just to get that self-proving status. If a QES isn't available, think whether you actually need to have it being self-proving or not. Does it make a difference? And this is all about looking at the benefits and the convenience against the risks for that document. One of the other issues that's come up is around deeds of adherence and assembling conformed copies. So if you have a complicated contract being signed by lots of different parties, if you're wanting to then assemble a final version, that might be difficult with an electronic document, because if you start trying to combine them into a single document, then the electronic signatures will fall off, for want of a more technical term, that document. So they won't be in it anymore. You can't merge two electronically signed documents together in the way that you could, for example, compile wetting signature pages and then scan them together. So that's just a practical issue to think about with that. Certified copies is also something we get questions on. How do you certify an electronic document? Well, actually, do you need to ever certify that? Because the benefit with an electronically signed document is everyone gets or can have their own original. You can have what I call duplicate originals. So you can share the signed document with as many people as you want, and everyone has something which is identical to the electronic file that's been signed. So we shouldn't actually need certified copies anymore when we're dealing electronically, if you can share that duplicate original with the recipient. And then the final point there, which I think has fallen off the bottom of the slides, is just that I think it's important for organisations to look at developing playbooks for all of this. So it is complicated. There are lots of different ways you can sign, and there are different risk profiles for different types of contracts. So one of the things that we do with clients a lot is help them develop contracting playbooks which look at the sorts of contracts that they sign, and help set policies around what sort of signing approaches they're happy with. So there may be some things you still want to do in wet ink. There'd be other things you're happy to do electronically. You might be very happy with a very simple, basic type signature for some contracts. For other things, you might want something more complex. So if that's something we can help with, more than happy to do so. And then I think just onto the last slide, there are just some useful resources here, which you can have a look at your leisure. There's the Law Society of Scotland Electronic Signatures Guide, which was published in January this year, and I chaired the Law Society's working group in that. And what we tried to do that is provide something which is quite practical and useful. It talks a lot about some of these risk issues rather than just focusing on the law. So do have a look at that if you get a chance. There's a similar guide from the Law Society of England and Wales. There's a link there. I don't think it's quite as useful because it doesn't really talk about that risk point. It's very legally focused, and it doesn't cover issues like what sort of signature should you use based on the level of risk, what information do you get for different types, but it does give you an overview of English law. And then just finally there's a blog that we published back at the start of COVID-19, just with a quick summary of everything that we have spoken about. Back to you, Claire.
Thanks very much, Martin. So thanks to all of our speakers as well. It's now time for questions. So we've got about 5 minutes left. I've picked up a few questions from the Q&A function. So I am just going to dive right in with that. So Ross, first question for you. Does the white paper say anything about new oil and gas field developments on the UKCS?
So
That's it, you're on.
Sorry, I think I'm on, yeah. So the paper doesn't address any new field developments explicitly. However, I think when discussing investment and alongside the net zero challenge, the paper notes that whilst the government obviously expects industry to respond to net zero, and equally it will also encourage continued healthy levels of investment. So I would kind of suggest from that following on from that and the continuing kind of Majeure UK objective, new field developments will undoubtedly continue in order to maintain obviously security of supply and ensure that we have an orderly transition. So and just on that as well as I mentioned, there might be additional kind of processes added to the licensing regime. So worth being aware of that as well.
That's great. Thanks, Ross. And one for you, Elaine. You mentioned that some people will have to apply for a frontier work permit by 30th of June. Is there a deadline when the scheme will close?
So the scheme isn't going to close as such, but any individuals who do want to be coming into the UK from the 1st of July onwards will have to have one of these permits if they're going to be working. So yeah, it's worth applying just now. The application process is kind of online, but you have to submit some supporting documents and it might take a period of weeks for a decision. So yeah, we're telling people to get their applications in now, but no, the scheme will remain open if you decide to apply at a later date.
Super, thank you very much. Question here for you, Laura. Is there any intention to link the UK and the EU schemes?
Possibly. Both the EU and the UK scheme managers have set out a target date of the 2022 close of scheme, so 30th April 2022. And they will look at the two systems and how they've worked over the last year and where they could possibly have crossovers or mergers or allow trading between the two schemes of the different types of credits. But they're not going to know until we've seen how the UK system operates for at least a year.
Okay, thank you. Adam, one for you. You discussed recourse to the common law if COVID isn't covered by force majeure, but also suggests that exercising common law rights might be prejudicial. Can you explain this, please?
Sure. The reason why I say that is that the closest equivalent we have in common law is the law of frustration. But the law of frustration it's generally a harder test to satisfy than what you might draft in force majeure provisions. So under the law of frustration, in order for it to apply, the obligation has to now be something which is radically different from what was originally envisaged under the contract. So you've got that higher threshold which you might have to meet, but the effect of applying frustration is much more severe than force majeure. Whereas force majeure can allow for suspension of the contract, and you could provide in your contract that it's going to be a set period of time, or it could indeed be indefinite, as in the logic contracts, for example. What frustration does is automatically discharges the contract at the point in time that the frustrating event takes place. So whilst you will have some reallocation perhaps of costs for monies incurred up to the point of frustration, at that point, that's it, the contract is dropped and both parties walk away. So you'll have a situation there in which you've gone from potentially delayed performance now to no performance whatsoever, and you're having to go out and contract again with perhaps another counterparty for services. So you could end up in a far worse situation where it takes you much longer to get performance, and it actually you just accepted force majeure for 2 weeks, 30 days, however long it would take.
Thank you. Thanks for that. And one last question I think we've got time for, and this one's for you, Vanessa. How will the OGA enforce the new obligations on net zero targets and CCS projects?
Well, in principle, we have the Chapter 5 of the Energy Act 2016, which provides for the process of the OGA to give notices on failures to comply with a petroleum-related requirement with jointly or 2 or more persons. We'll have to see, because the revised strategy is quite new and just came into force, how the OGA's powers will evolve and if they will be somehow uniformed compared to the powers that the OGA currently has for maximizing economic recovery. So still unclear how it will work.
Okay, Thank you so much. And that's all we've got time for. It brings today's session to a close. So thanks to all of our speakers. Thanks also to all of you for joining us today. We hope you found this webinar useful. Keep an eye out on our website, brodies.com, for details of our next Oil and Gas Academy series and all of our other events. Thanks again and goodbye for now.